Get ready. 3, 2, start. Case of the prosecution is that accused was found in possession of 200 bottles of illicit liquor under suspicion, and thus the instant FIR was registered against him. Stop. It is relevant to mention here that in a criminal case, the prosecution is casted with very serious duty to bring on record quality evidence in order to substantiate its allegations against an accused person. Stop. It cannot seek conviction of any person without bringing substantial evidence on record, as it becomes extremely difficult for the court to pronounce a person guilty in the absence of evidence nailing guilt by the accused person. Stop. In the instant case, prosecution has miserably failed to prove the guilt of the accused. Stop. It is observed that the investigating officer of the case had produced and proved the case property during the course of his examination in chief, but during cross examination he admitted that case property does not bear any seal or slip. Stop. If there is no seal or slip on the case property, then it cannot be said that it was the same case property which was recovered from the accused. Stop. In order to bring home the guilt against the accused, it was necessary for the prosecution to prove the case property during the course of trial in order to connect it with the accused properly. Stop. Another defect in the instant case is that police has not joined any independent witness at the time of alleged recovery. Stop. During cross examination, investigating officer has admitted that he has not taken any action against those persons who refuse to join as independent witness. Stop. Therefore, it is violation of mandatory provision of law. Stop. The Honorable High Court has held that where the investigating officer himself admitted that the independent persons were tried to be joined in investigation, however, none of them joined, and the investigating officer did not record their statement or proceeded against them. Therefore, such statement of investigating officer is nothing but a farce. Stop. There is also unexplained delay of 7 days in sending the sample to the office of chemical examiner. Stop. Although it is settled law that mere delay in sending the sample to the laboratory is not fatal to the prosecution case, but in the instant case, the prosecution has not been able to explain the reasons for delay. Stop. As such, prosecution has failed to connect the accused with alleged recovery. Therefore, accused is acquitted from the charges framed against him stop.